Mr. Domina, good morning.
Good morning, Your Honors. Thank you. May it please the Court, I'm Dave Domina. I'm here on behalf of Bridgeport Tractor Parts. The appellant's position here asks this Court to review a ruling of the trial court admitting expert evidence. Your cases teach that the standard for that review is whether the trial court abused his discretion. The trial court was presented with an expert witness who was qualified. His qualifications were not challenged in a Schaefersman hearing or otherwise. His methodology was attacked with effective cross-examination at trial, and his direct examination was punctuated with objections, some of which were sustained, requiring that additional foundation was laid until the trial court was satisfied that there was sufficient foundation and made a decision based on a quality record to admit the evidence. The issue was whether the seller of a business competed unfairly with the buyer in two distinct ways. And I think it's important to dwell for just a moment on those two different methods of alleged inappropriate competition. The businesses involved here first accumulate inventory through methods of acquisition that involve farmers bringing in old machinery, going to old machinery auctions and sales, and having people out in the countryside scouring to buy old tractors and other implements so they can be salvaged and an inventory of parts can be obtained. There's no other way to get a base from which sales can be made. So a very important part of the business is to be able to buy goods. And an important part of locking out the seller as a competitor was to keep the seller out of the business of buying up the available inventory. That was the first competition sought to be eliminated in the contract. The second, of course, was then once an inventory might have been gathered by the seller to prevent the seller from selling it at retail. Both events occurred, we contended, inappropriately here, and the jury agreed. Mr. Wanande, the accountant and business valuation expert, was asked to assist in determining the extent of damage. According to the defendant's expert witness, he used the three recognized methods for doing that. They're called the simple before and after approach. How is the business doing before and how after? He concluded that approach could not be used because of inadequate data about a prior to sale process. The second approach he used was a strict comparison approach. I find other companies that compare with the one I'm studying. I isolate their similarities, identify their differences, adjust for the two. After adjusting, use the comparison as one of the methods of determining loss.
So there were adjustments in his testimony?
There were, Your Honor, and there were adjustments made in three essential ways. The first way was that he adjusted the gross margin, the adjusted gross margin, downward from 7%, which was the Wisconsin companies operating at a pre-tax margin of 7%, to 5% for this business, thinking that the expenses were higher. So he accommodated the differences in expenses by shrinking the margin. They had more expense, they made less money. The second thing he did was to consider the difference in the sales volume and the number of the customer base and the area, and concluded that while the population was less dense, the area in which there was no competition at Bridgeport was significantly greater in Wisconsin, so the comparison was favorable. He didn't care about whether the crops were different. He's talking about used equipment parts, and those parts are needed whether you use the tractor for wheat or for corn or for green beans.
Mr. Domina?
Yes, Your Honor.
Does the record reflect, he used two Wisconsin companies, they happen to be companies owned by him?
Yeah, owned by my client.
By your client. But does the record reflect whether there were any comparable companies in a closer geographic area in Nebraska say that could be used?
It reflects consideration of the question and the conclusion that there were none. There's a reference to a small company at Morrill. There's a passing reference to a used equipment dealer up at Cornlee in Platte County. They were not compared. They were not considered to compare favorably because their business models were quite a lot too different and their inventory offerings significantly different. These two in Wisconsin were 2 of 8 owned by my client. And these 2 were differentiated out from the others, primarily, Your Honor, because of their startup time, the duration of their operations, and the nature of the business. That is, the kinds of equipment they were trying to collect and salvage, and then the kinds of parts they were offering for sale. Those factors were all considered. Mr. Gredicke, an accountant called by the defense, gave some interesting admissions on pages 901 through 904 of the Bill of Exceptions in particular, where he concedes the $1 million starting price from which our calculations proceed. He concedes that the methods employed were the appropriate ones to consider, and he doesn't really dispute significantly the adjustment of the 7% down to 5% margin, which accommodates all of the expense side of the balance sheet and the businesses being compared. So we really think that the defense expert went a long way toward fortifying our record and confirming that the trial court did not abuse his discretion at admitting this evidence. The second assigned error brought here, not argued this morning, concerns instruction number 7. It's essentially an NJI instruction. The argument in the brief is that the evidence of loss should not have been permitted to extend beyond the 5-year duration of the contract, and that instruction 7 should have informed the jury that the damages were limited to 5 years. Instruction number 2 refers to the specific 5-year contracts in question by exhibit number, tells the jury they're confined to the evidence, and informs them essentially that the theory of damage here, not saying theory, is to put the buyer in the position that the buyer would have been in without a breach.
I'm sorry, you're saying instruction number 2?
Instruction 2 helps to eliminate any doubt about whether 7 contains an error.
2 is what,
Two
the
is the
nature
statement
of the case.
It's a
The judge
statement of
tells
the
the
case.
jury, here's where we're going.
That's right.
What it's about.
And I might mention that it refers to the contracts in dispute which contain the 5-year duration by specific exhibit number, 270 and 271, I think. May I have just a moment on the cross appeal? The cross appeal is mine. It presents an issue of law. It presents a close question, a question that I thought I needed to raise for you here, and I was uncertain about. And that's why there's another lawsuit pending over the same subject in district court. My client paid $476,000 as a result of a non-execution sale under a deed of trust of a parcel of real estate sold as a part of the transaction that included the sale of this going concern business or inventory and business that we purchased from Gary's. That execution, I'll call it execution, that trustee's sale under the deed of trust occurred because there was a claim of a default under the promissory note that the jury concluded here was void because of Gary's breach. That means my client paid $476,000 under a promissory note that has been declared void. I contend we're entitled to restitution of that money, and that the trial court was confronted with a question of law on that issue, ruled incorrectly, and should be reversed here.
Is that the basis of another same issue on another lawsuit?
Yes, it is. It is, Your Honor, and that subsequent lawsuit was filed to protect the statute of limitations in case I shouldn't be raising it here. And there's a question about whether I should be raising it here, I think primarily because that issue arises under the deed of trust and not under this contract. And that's what I want to alert you about. It's a close question, and I want you to know why I brought it here. If you decide I'm wrong on the cross appeal...
How was this raised at trial?
It wasn't. It was raised with pretrial motions. One of them in 2006 and another one about 3 months before the trial, with the same result both times.
What would be the mischief if we just said, well, there's another case on file dealing with this exact same point?
None, Your Honor. That's fine. And in fact, what I was going to say is if you decide I'm wrong on the cross appeal, I encourage you to be specific with your remand instruction on that point. And that's where I was headed with my remarks.
Does this case have I want to say, the right pieces of paper to look at it?
The deed of trust is in the record, but there's a really serious question about whether it's right procedurally here. And I was just unsure enough, I didn't want to not bring it to you, but I'm only cautioning about the remand order if you decide against me on the cross appeal. Thank you very much.
Thank you.